I'd like to talk about a couple of other scenarios. Disability of a shareholder. It's typically important where the shareholder is an employee, and the provision will provide for disability payments and potentially even a requirement to sell the shares of the family member in case of a prolonged disability, meaning they're not going to ever be able to come back to work. This is a very tricky clause. It needs to be drafted in conjunction with assistance with the insurance provider so that the terminology in the agreement is consistent with the terminology in whatever policy may be in place to fund the disability. Death of a shareholder is the next scenario. Can shares be transferred to my heirs on my death? And that will depend on the succession plan of the family. Typically, we see very significant restrictions on who can inherit shares, and there will usually be a provision to provide for insurance to fund whatever buyout may be planned for. The use of insurance in a share buyout is very complicated and can be structured in a variety of ways. When I'm acting for my clients, I am typically going to be seeking advice of the insurance provider and the accountant to ensure that it's structured properly and that it works in the most tax-effective way to benefit both the purchaser, the corporation, and the estate of the deceased sibling or parent or whomever it happens to be. Okay? The third scenario that I want to deal with briefly is marital breakdown. Those of you from Ottawa will recall the ugly fight between the McCaffreys over the bridal shop. I'm not a family law lawyer, but in Ontario, the Family Law Act provides for a property equalization mechanism. And if the shares that you own in the family company represent a large proportion of the value that you have, you need to have a mechanism to fund the buyout of the soon-to-be divorced or separated spouse, or shares may have to be transferred to settle the equalization claim. It's a very complicated and a very sensitive area within the shareholder agreement. Oftentimes, there may be marriage contracts that precede your even being able to become a member of the family business. And so acquiring shares may be conditional upon having such a contract in place. But that's a decision that you need to handle very carefully and very delicately. I am involved in a significant family business right now where any kid that works in the business has to have a marriage contract that excludes the value of the business from their net family property. This is a provision or a condition that was not imposed by mom and dad. It was actually imposed by brothers and sisters. There was a family meeting. They asked mom and dad to leave the meeting, and with their insurance advisor and financial advisor had a talk about this, and they all agreed that if any of their brothers or sisters want to come into the business, they have to have a marriage contract. That's one way to deal with it. That's pretty atypical, though, but it is an issue that has to be addressed. All right. So if we move on, I want to just talk briefly about some financing. I think we have to recognize on how businesses, family businesses, are funded, and not everybody in the family has the same resources as others. And that's not necessarily any different than a non-family business, but the agreement will probably deal with funding requirements, cash calls, loan guarantees, whatever contributions have to be made. There is the issue of exit strategies. It's another difficult area, price of disability, but under the category of the other issues of evaluation and it's a dirty evaluation. Assessment value. And also, briefly, I mentioned the cancellation clauses. They are difficult in non-family business shareholder agreements. Not necessarily family business and business shareholder agreements, but issues need to be addressed. You may decide that you're not going to include them, but I think it needs to be put on the table. Okay. I have. I'm getting near the end here, so we'll come to any questions that you might have in a moment. I've experienced situations where owners have entered into shareholder agreements without really fully understanding the impact. By the time they turn to counsel for advice, perhaps the damage has already been done to the family business. And I think you need to remember that the shareholder agreement can protect you, but it also restricts you and your rights as a shareholder. So to the extent possible, I think you need to test drive the agreement before signing it. But realistically, you need to be somewhat flexible and agree to be able to amend the agreement to deal with issues that come up. Because no matter how extensive you or your advisors understand the agreement, it's impossible to account for all of the possible situations. So that's really the end of the formal part of my agreement.